by the exhibit FRSCC informed that were wrote exhibit FRSCC this certificate and handed it over to the counsel for the claimant. As at the time judgment was delivered on the 6th day of February 2019, the claimant was no longer alive as he died on the 22nd day of June 2018. That this court has power to set aside this judgment obtained by fraud, concealment of the claimant's demise. A written address was also filed along with the motion on notice, wherein sole issue was formulated for determination, to which whether this honorable court has the Mr. Kletos Okukom versus Mr. Boboe Oyemi and another, considering the prevailing circumstances of concealment of material facts and fraud. In arguing the sole issue for determination, Simwe C. Mbagbo, Esquire, counsel for the defendant's applicant submitted where that the jurisdiction is live wire of the court, because if a court determines a matter where there is no jurisdiction, the proceeding is null and void and of no effect whatsoever. Counsel further relied on the case of Madukolo versus Nkembe reported in 1962 SCNLR 347. She also relied on Oloa versus Akereja reported in 1988, 3 Nigerian Criminal Report, part 845, page 508. Counsel then urged the that jurisdiction to proceed with hearing and deliver judgment on 6th day of February. During the pendency of this suit, counsel submitted that dead person has no legal personality in the eyes of the law. In support of this contention, reliance was placed on the case of Uzoma versus Jinadu, reported in 1987, 2 SC 153. Counsel further argued that when the claimant died, counsel did not substitute with another legal person to take the place of the deceased claimant. On this contention, the case of Madukolo action, including an appeal in low court, counsel relied on the case of Tesi Ofebi versus Shitu Oshoboja, reported in 1976, 9 SC 10. She also relied on Ihimibai versus Omoka Oje Iboi Esekong, reported in 1993, LPELR 2649 SC. Counsel also refers to Order 13, Rule 27 of the rules of this court, and contended that the claimant should have.
I just connect now.
Court has unfettered power to set aside or concealment of death of the claimant during the pendency of this suit. In reaction to the motion on notice, a 24 paragraph affidavit was filed. The said 24 paragraphs affidavit was sworn to by one Mrs. Mary Okukong, the wife of late claimant. In the counter affidavit, the defendant stated that she was lawfully married to the late claimant, and the marriage was blessed with 2 children. Stated that the death certificate was attached as Exhibit A02. It is stated that Exhibit FRSCB was concocted and defendant are hereby of the date of the claimant, which was done by the Exhibit A03. A copy of the affidavit, a copy of an affidavit was also attached to the counter affidavit, which was titled Affidavit of Death, sworn to by the deceased wife, wherein it was averred that the claimant respondent died on the 22nd day of February 2019, shortly after judgment A04, the defendant made reference to death certificate attached to it as EXHA. The counter affidavit was accompanied by a reply address wherein 3 issues were formulated for determination. They are: 1, whether claimant now deceased is entitled to his arrears of salaries and other financial benefit accrued to his on account of his wrongful termination of employment. B, whether claimant by virtue of this judgment entitled to death benefit from his employment. C, whether the defendant applicants can be allowed to benefit from their own wrong. Counsel jointly argued issues A and B above. Oliver A. Osam Esquire, counsel for the play was wrongfully without notice withheld by the defendants since September 2016 and subsequent in December 2016. The claimant now deceased remains in the service of the defendants until judgment was delivered. It is argued by counsel that this court cannot reported in 2017 all Federation Criminal Report Part 882, page 1302. It is submitted. This court is functions of issue cannot set aside this judgment. It is the submission of counsel that assuming but without considering that the case of the claimant, the case of the claim the 26th day of February will not affect the case. On the 22nd of June, 2018 will not affect the case. On this submission relies on part 964, page 19, 1930. He also relied on Abdul Salami Aweda and two others versus Malan Abubakar Baba Alafuni, reported in 2018. All Federation report, Part 9. Page 802, submitted by the provisions of Order 13, Rule 27, Sub 3, Court can proceed with judgment even where claimant was reported dead. Counsel submitted the provisions of the rules are clear and unambiguous and should be given their ordinary natural meaning. In support of this view, counsel relied on the case of Lawrence versus PDP, reported in 2018. Only admitted that it is tried to law on both criminal and civil jurisprudence that a party is not allowed to benefit from his own wrong. The principle is in line with principle of equity, that he who comes to equity must come with clean hand. It is submitted that the claimant cannot be allowed. The defendants, applicants, cannot be allowed to benefit from their own wrong. The claimant, now deceased, was wrongfully terminated in November 2016 and proceeded to court against the defendants. And after 4 appearances, the defendant, irrespective of his termination of employment, was struck down by stroke occasioned by physiological trauma. Counsel submitted this court is Pontius official lacked jurisdiction to sit on appeal to support his contention relied on the case of Emeka Ehedioha and another 1,257. He also relied on Dingyadi versus INEC, reported in 2010, volume 6 to 7, MJSC at 1 at page 23. In concluding his submission, counsel urged the court to refuse the application for Lucky in marriage. The defendants, applicants, filed a reply on point of law. Filed a reply on points of law, wherein it was argued on Pontius official that there are instances where a court can set aside its judgment, and more so when it was given in error. On this, counsel relied on the case of 2007-17 Nigerian Mukilolo report, part 1062. Counsel also relied on Pajimi versus Speaker Western Region of House of Assembly, reported in 1962, 1 HCNLR 300. Counsel submitted in view of the contradictory evidence justice will be served if oral evidence to buttress the point be made. Counsel relied on the cases of Mark and another versus AK. AK reported in 2004, 17. Counsel also relied on the case of Elmiski Limited, no proper citation. Atenda Olarewaju 1988 for Nigerian Criminal Report. Part 89, page 390. One Nigerian Criminal Report, part 168, page 405. It is the submission of counsel on the date of certificate that failure to attach this certificate purportedly annexed is fatal to the claimant's case. In concluding his submission, counsel asked the court to grant the application and set aside judgment of 6th day of February 2019 for having been given without jurisdiction due to death of the claimant during the pendency of the action. This is the court's decision. I carefully considered the motion on notice. The affidavit is support together with the exhibit attached therein to the submissions of counsel for and against the motion on notice. The counsel for the defendant's applicants has submitted a single issue for resolution, while counsel for the claimant respondent formulated 3 issues for resolution by the court. I must observe that the 3 issues formulated by the claimant respondent were not did not capture the essence of the issues raised by the motion on notice. Therefore, the 3 issues formulated by the claimant respondents are hereby discountenanced. In an action before the court is only bound to consider the press submitted by the applicant as per motion papers. In the case at hand, I shall restrict my consideration of this application to the relief press contained in the motion papers. The issues raised by the claimant in his address concerning the unpaid salaries, entitlement of unpaid salaries, and this benefit to the claimant's respondents were not properly before the court. Those issues are hereby discountenanced. The act arbitrarily, but judicially and judiciously based on sound principle of law and by giving weight to the relevant consideration, that is the evidence put before the court. See the cases of Nigerian Laboratory Corporations versus Pacific Merchant Bank Limited. See also the case of Anna Chebe versus Ijeoma. In the exercise of discretionary power, one one way or the other. The court has to take. Court must always exercise its discretion only on the basis of the materials placed before it and on no external consideration. See the case of CFA or Nigeria PLC versus Sanu. Both a court have consistently held that an applicant who seeks the exercise of court discretion in his favor has a duty to place before the court sufficient materials to satisfy the court that he is entitled to a favorable exercise of the court discretion. See the case of Alama Siega versus Federal Republic of Nigeria. See also the case of SCO Nigeria PLC versus Omoshola. The Institute of Justice the duty to support his application with all the necessary evidence, and it is the corresponding duty of the court to determine whether the applicant has discharged his duty in that regard. If he fails, it is just right and fair that the court should refuse to exercise discretion in his favor. See the case of Sholanke versus Some Fokun, also University of Lagos versus Igboro. See also Ali Finda Kwajafa versus Kwajafa Gai. Limited versus Borno State Watching on the matter, whether obtained by consent of the parties on the matter or on its merit, it ceases to exercise further power in dealing with the case as it has become functus officio with regard to that matter. What it means is that a court cannot sit on as an appellate court over its own decision. Once it has decided a matter, it ceases to be seized of it and cannot reopen it for any purpose whatsoever, save with respect to such ancillary matters as stay of execution and possible of the judgment, instrumental payment. See also Ukachuku versus UBA. See also Obolu versus Ivoli. See also Sun Insurance versus IMBS Limited. All citations have been provided. There are, however, instances in which the court that gave a judgment is permitted to set aside such judgment. See Order 38 Rule and see Order 38. See also Order 47 Rule 22 of the National Industrial Code Civil Procedure Rules 2017, where provisions were made to allow for setting aside judgment or orders obtained in default of appearance of one of the parties or default of pleading or for which for any reason whatsoever, as for example, lack of jurisdiction, the court becomes, for lack of jurisdiction, the judgment or order becomes a nullity. See the case of Koli, Ojiako and others versus Onwuma, Ogweze and others. See also Udo Idion, Ekerete versus Udo Enwe Eke. See also Craig versus and others. All citations have been provided. Or where it is obvious that the court was misled into giving the judgment under the mistaken belief that the parties consented to it. See Ganiu Agunbiade versus Okunoga and Co. See also Aguda in practice and procedure, 1980 edition, page 531. Article 4.4.21. There is no doubt that a court of record has by reason of supervening events rendered defective. Such supervening events, which may cause a offending suit to become defective, is based upon either of the parties or either of the sole claimant or sole defendant or both. See the case of Wahab Al-Musafo and another versus Al Hajar been to Smolu reported in 2010 applicants who wanted the judgment of 6th day of February 2019 to be set aside is that counsel for the claimant was well aware of the death of his client on the 22nd day of June 2018, but failed and neglected to disclose the information to the court. And the court went ahead to entertain the matter, which was via originating summons, and delivered judgment when the claimant was no longer a juristic person as a result of his death. The counsel for the defendant's applicants argued that with the effect from 22nd day of June, applicant are by their motion or notice praying for setting aside the judgment of this court delivered on 6th of February 2019, which according to them was delivered when the claimant respondent was no longer in existence due to his death on 22nd day of June 2018. The defendant's applicants also stated that the counsel for the claimant concealed the dates of the claimant to the court and the applicant, as counsel had always apologized of the absence of the claimant at the last 3 days came up before the court. It was the case of the defendant's applicant that from 22nd day of June 2018, when the claimant respondent died, he ceased to have a legal personality. From the counter affidavit filed in opposition to the motion on notice, the deponent of the counter affidavit she also claimed that the claimant died during the pendency of this suit. She also claimed that the Exhibit C, Exhibit FRSC, she also claimed that Exhibit FRSCB, letter by the Reverend Paza, was concocted and forged. She also placed reliance on the death certificate that the claimant, the death certificate she referred to in her affidavit, in her counter affidavit, which 18 as claimed by the defendant applicant. It is clear from the facts as disclosed in the affidavit evidence that there is no confidence regarding the dates of the date of death of the claimant. That is, the dependents and the claimants are not at idem on when the claimant died. The defendants applicants have stated in their affidavit in support of the motion on notice that they got to know about the demise of the claimants respondents through a letter written government area inviting the commander to attend the burial of the claimant respondent that took place on the 27th day of June 2018. See Exhibit FRSCV. The defendants applicants have by the Exhibit FRSCC dated 9th day of May 2019 written to the Holy Family Catholic Hospital for a copy of claimant's death certificate. The defendant's applicant, however, averred that they were told that by the officials of the hospital sorry, my internet was interrupted. I continue from where I stopped. The deponent of the counter affidavit who claimed to be the wife of the claimant had, in opposition to the motion or notice, deposed to the effect that the claimant in this suit died on the 22nd day of February 2019. To buttress her claim, she stated that she is relying on Exhibit A02, death certificate, and by the Exhibit A03, she stated that the defendant applicant were notified of the demise of the claimant respondent. It was also deposed in Exhibit A04, affidavit of death, said to have been affidavit of death that which was deposed to at the High Court of Justice of Cross River State that I have observed from Exhibit A03, the purported letter of notification of death. It did not state the date the claimant respondent died, nor was a copy of death certificate attached to indicate the correct date of death of the claimant. This means Exhibit AO has no evidence value. Furthermore, at the Cross River State, the deponent stated that a copy of death certificate, claimant's death certificate, was attached to the affidavit as EXSA. Surprisingly, however, there was no such certificate attached as per the deposition in paragraph 6 of Exhibit A04. To make matters worse, the purported death certificate stated in paragraph one of the count in paragraph, as it was never attached to the counter affidavit as claimed by the deponent. Therefore, the failure to attach a copy of the claimant's death certificate is fatal to the veracity of the depositions in the counter affidavit. This also means that the claim of the claim respondent that the claim it is a false, it is hereby discountenanced. With these findings, The claim by the defendant that the claimant died on 26th day of February has not been proved, as the deposition in the counter affidavit have not shown to be reliable, but have not been shown to be reliable due to lack of cogent and compelling evidence. It is also to be noted It is also to be noted that the deponent of the counter affidavit has stated that the exhibit FRSCB was forged and concocted, but no evidence is that the alleged forgery is one that has the burden of proving such forgery, and it has not been proved that exhibit FRSCB is forged. The allegation has no basis and is hereby also discountenanced. For the defendants applicants, they rely on exhibit FRSCB is to the effect that exhibit FRSCB is to the effect that the claimant respondent departed this world on the 22nd day of June 2018, and that his burial was to take place on 27, or took place on the 27th day of February 2018. This letter, exhibit FRSCB, was dated 25th day of June 2018. This is because the defendant applicants have not in their affidavit evidence stated the letter was not received on the date it was stated, on the date it was dated. There was also no any evidence to show the actual date of receipt of the letter, which is before the court on 17th day of October 2018, that is after the death of the claimant, and on 7th day of November 2018, with all the parties being represented by counsel, and none of the counsel informed or drew the attention of the court to the demise of the claimant respondent. The judgment in this case was delivered by court on 6th day of February 2019 of the claimant respondent. The defendant's applicants are now claiming for setting aside of the judgment of 6th day of February 2019 on ground that, as at the time the judgment was given, the court has no bias to deliver it, as the claimant respondent had died in the course of the hearing of this case. Ordinarily, where a court is aware or becomes aware of the demise of any of the parties, the suit abated or becomes suspended, depending on the nature of the interest involved, if the case is personal to the course of action. However, where the suit is not personal to the party, it survives the death of the survives the death of the claimant, then substitution will take place upon proper application being made to the party involved by the party interested. See the case of NDIC versus Rosa Ball Nigeria Limited. If it is true that the claimant respondent passed on during the pendency of this suit before the court renders its judgment on 6th day of February 2019, the counsel appearing before the counsel appearing before the court have the obligation to bring to the notice of the court the said demise of the claimant. However, the record of the court is their responsibility by pressing on to continue with the hearing till the judgment was delivered on the 6th day of February, 2019. It has also been argued before me that the court was aware of the demand. It was not argued. It has not been argued before me that the court was well aware of that. The court was not aware of the dates of the claimant respondent when the judgment of 6th day of February 2019 was delivered. If the court had been aware, it would have afflicted the judgment with virus of nullity. By the delivery of the judgment on 6th day of February 2019, this court has become functis official and cannot review or often the matter for the hearing. Is 428. The court held it is settled law that a dead person ceased to exist in the eyes of the law, and any cause of action pending against such a person automatically abates, unless it is one that survives the person. The case, as I pointed out earlier, this case as I pointed out earlier, this case is such that survives the claimant. In the circumstances, even if there was no information even if there was information to the court about the death of the claimant before the judgment was delivered, the court will not will only sustain the hearing instituted against a legal person, but who has since died or instituted by him while he was alive, like in the case at hand, but is now dead, will henceforth abate unless appropriate steps be taken to substitute a living person for the disease. Without such substitution, a judgment obtained against or in favor of the dead person is a nullity and cannot be binding. Cannot Bailey Abraham Judgewell has this to say: I also accept as correct in law the submissions of appellant's counsel that a judgment of a court, if obtained against a dead person, must, with a caveat, being that the death of the party must be to the knowledge of the court. Such a judgment is a nullity and liable to be set aside with much ado, and a court has inherent power to set aside its own judgment, which turn out for whatever reason to be a nullity. See Onye Kulone versus Indule. See also Dehua and Ade Dinaran. See also Igwe versus Kalu, to complain, having been aware of the death of the claimant respondent by the exhibit FRSCB and not informing the court or taking steps to do the needful at that time. The court cannot be blamed for the situation. There is no doubt, as rightly stated by the Supreme Court in the case of Sufo versus Sumonu Sufra, while citing with approval the case of Akumujo versus Masadorum, that a judgment obtained or in favor of a dead person is a nullity. At hand, even with the supervening event of death, the case before the court will only be temporarily suspended until the taking of formal steps for substitution of appropriate party with requisite legal personality to continue with the case. Since the case of the claimant is not the one that abate completely, the failure, it survives the claimant. The failure to apply has made this court to become factus officio. The council cannot now apply for setting aside, as they have themselves to blame for not bringing to the attention of the court the demise of the defendant. Has not brought to the attention of the court the demise of the defendant. It is before concluding this ruling that the conduct of the counsel for the claimant in filing an affidavit claiming to have exhibit and not attaching those exhibits to the said affidavit is condemnable. And it amounts to dereliction of duty to the court. As minister in the Temple of Justice, counsel is for the claimant in the way the affidavit, counter affidavit was filed without the appropriate exhibit. Has defeated counsel of intent to deceive and mislead the court. NDIC, Rosabon Nigeria Limited, the defendant's applicant's application fails and is hereby refused. I make no order as to court. Ruling entered accordingly.
The court pleases.
As the court pleases.
Thank you very much, Council. Thank you, Council. We have come to the end of the virtual sitting.
Thank you, my
can
lord.
get
Thank
your
you, my lord.
ruling. Yes, you can get your ruling. The ruling will be ready by tomorrow, and you can access it on our website.
The court pleases.
As the court pleases. Thank you, my lord.
The administrator, you can end the sitting. Thank you.
I think it's just been for 30 years.